get a number of questions regarding evidence in criminal cases, and naturally there is a suspicion on behalf of defendants that the prosecutor is not dealing even-handedly with them, and that they're possibly withholding evidence or not turning over everything, or there's some issue with evidence. And so we always get questions about what evidence does the prosecutor have to turn over to me. And there are some misconceptions out there. Both defense lawyers and prosecutors have misconceptions about what we call Brady obligations. And of course, Brady obligations is from that 1963 case, Brady versus Maryland, about what evidence the prosecutor has to turn over. Here's a few misconceptions. There's a misconception that prosecutors only have to turn over exonerating evidence. And that misconception is false. Prosecutor has to turn over all evidence that is in their possession. Another misconception is that only Brady evidence in the hands of a prosecutor has to be turned over to the defense. That's a misconception as well. It's not only Brady evidence that they have. In fact, there are several case laws out there that says that prosecutor has to seek out all evidence. The prosecutor does not get to be the construct of a criminal proceeding. They have to pursue all leads, interview all witnesses that even may potentially have exculpatory evidence, especially if a defense counsel or a defendant says, hey, I think there's some exculpatory evidence over here. The prosecutor is bound by law, bound by case law, to go and seek these things out. Another misconception is that evidence that falls under Brady can be given to the defense on the day of trial. That's false. They have to give you enough time to analyze the evidence so that you can craft a sustainable defense. Remember, in the United States of America, you enjoy the presumption of innocence until you are proven guilty beyond a reasonable doubt. Another misconception is that prosecutors do not have to look for Brady material. They must turn it over only if they come across it. Again, as I previously said, that's simply not true. They have to look for evidence everywhere, even if it is exculpatory, and they can't kill you with the pencil. You know, they as we used to say when I was a police officer, pencil whoop you. You don't have good evidence, so they write the reports and all of this stuff in such a way to where it's slanted against defendants. It's against the law. They have to go search out Brady material. And then lastly, I think there's a misconception that prosecutors are never required to turn over their handwritten notes because these notes are privileged and considered work product. That's absolutely false. That is a part of Brady material. And again, you need to talk to, if any of these misconceptions are in your mind, you need to talk to your attorney very quickly. Get a competent attorney, because there's evidence that could be being withheld, whether knowledgeably or in bad faith or knowingly being withheld from you, that you are entitled to have to prove your innocence in your criminal case. And so call us, call a competent lawyer, but let's get all of the evidence, because the effectiveness of your defense is going to rise and fall on the evidence that you submit. So call someone quickly so that you can raise a sustainable defense.